And we are live on Facebook, and this is being recorded. Ladies and gentlemen, my name is Daniel Fruzen, founder of the Westside Bar Association. Thank you so much for being here with us tonight on Zoom, which I'm sure we're all getting pretty used to at this point. We have a interesting event tonight. It's a little different from the usual. And we made a post in the Facebook group and we said, hey, are you guys interested about the student loan situation? And there's a new administration and there's always, rumors and whispers. Is there going to be forgiveness? Is there not? I think clearly for all lawyers and even non-lawyers who have student loans, this is an incredibly important seminar that we're putting on here. We're very lucky. We have Mr. Stephen Chung, WBA board member. He is a tax attorney. He is here to help and assist, give you his insights on what's going on with all the student loan stuff. We also have Mr. Garrett Charity. He does student loan defense litigation. So clearly we have two people who are very much so on point in terms of their careers in this particular subject. And I'm sure I'm just as interested as everyone else here. One small request before we get started, guys. If you appreciate these types of seminars, if you appreciate this type of stuff, please post in the Facebook group. Please let us know. We trial balloon things. We have polls for a reason. I think we're the only bar association who literally says, hey guys, what do you want? Rather than providing you what we think you want. So if we put a poll up there, or if you have an idea for an event, just post it. It'll get one of our attention and we can take it from there. Okay, enough out of me. Mr. Chung, you want to take it over?
Okay, good evening, everybody. I just want to say welcome to everyone from Facebook, and I'm sure there's a couple from the Lawyer Smack chat group that I joined, as well as people from Above the Law. I'm also a columnist there, and I publish every Wednesdays where I usually talk about tax issues and student loans. So what I wanted to do today was I have a slide presentation, and we're just kind of going to go over some of the federal student loan repayment programs and their collection procedures, and as well as their forgiveness options. And then the final minutes of the program will talk about what's looking ahead in the future, what forgiveness options are available, as well as I guess the political issues involved. Okay, so let me just get onto the screen. Okay, let me see if I can. Okay, there we go. Okay, so we're just going to start with the basics on student loans. There are four of them, and then there's a couple of others, but these are usually the major student loans that are existing. The main federal student loan program now is the federal direct loans, and this is pretty much where the federal government gives the loans out, and then you pay the government back, usually to a servicer like Navient. Perkins loans is very similar. These loans are generally provided by the school itself, and also they also have similar federal protections like income-based repayment, but generally they're only available for people who have extreme financial need. The third is the Federal Family Education Loan, or FFEL loan. This is really the predecessor. They don't have this anymore, but this is the predecessor to the direct loan programs. Usually people who graduated maybe around 2010 or earlier, they probably have this. And usually you can tell because you probably have a lower interest rate than the current 6.8 that's with the federal direct loans. The way this is different is these loans are they're actually serviced by private banks, and basically the federal government is guaranteeing the loans in case there's a default. Now, I kind of mentioned this because unfortunately, for some people, their federal student loans are actually on hold right now. Interest is on hold, and also payments are on hold until September. But the problem is, if you have this FFEL loan, you're kind of screwed because you still have to pay that. I don't know why they put an exception for this one. I'm guessing the private banks, they didn't want that, so they kind of carved that out, which is bad for certain older, maybe for a different generation. Okay, and finally, private loans, and Garrett will get more into this later, but these are just basically loans they're not secured by the federal government. These are just private loans given by private banks. Usually what's special about these loans is that, I mean, they're specifically used for an educational purpose. they're only designed for specific educational costs, and it's usually given as part of financial aid package. So basically, when you apply to school, and if the federal loan didn't cover the tuition and your room and board, then you have to use private loans as to cover the difference. Now, this should be distinguished from personal loans used to pay educational expenses. This is a totally different ballgame because usually you get this you just get it as a personal loan. You might use it just um, to pay for school and things like that, but it's really just a personal loan. There's no special attachment to it. I guess for most of the lawyers here, a good example is a bar exam loan. That's not really an educational loan. That's more of a personal loan that's just being used to pay for your bar exam education or bar prep. Okay, I'm just gonna go, Garrett and I are gonna go a little bit over collection procedures and settlement because when I do these seminars, there's always a few people that kind of come here because they're in deep hot water. I mean, they're being, they're getting letters, maybe they ignored the payments or they just couldn't pay and they didn't know what to do. And some people are just really in deep, their wages are being garnished, their tax refunds are being seized. So some people, they kind of want to come here to see if there's anything that they can do to kind of get out of their mess. So I kind of want to go over this a little bit. Okay, so with most federal student loans, you are in default if you don't make a monthly payment in more than 270 days, which I think is around 9 months. So usually if you miss a couple of months, the federal government, they send you a letter stating that you have to resume your payments, otherwise you'll be in default. The problem and then the consequence of default are they can garnish your wages, they seize your tax refunds, and they can seize some of your Social Security payments. The problem is that unlike your regular garden variety debt, they can do this administratively. They do not have to sue you. So, they can't take you to court. The other problem is you can't sue them and argue that they violated some kind of state consumer protection laws, mainly because of the supremacy clause in the U.S. Constitution. So so basically, you do want to definitely pay attention to your federal loan to make sure you're not in default. Okay. Thankfully, it's fairly easy to get back into rehabilitation status. You just need to pick up the phone and make a phone call with the servicer, and then try to set up a monthly payment plan. What you have to do is you have to make 9 out of 10 payments before you go from rehabilitation status to good standing status. Okay, the one other thing is if you are in default, you do not qualify for any other benefits such as income-based repayment programs or deferment. So you definitely want to get this rehabilitated as soon as possible. In the meantime, while you're in rehab status, your tax refunds could still be affected. So right now, this being January or February, you might want to adjust your withholdings so that you won't get a tax refund, but you have to pay your bills. Okay. All right, so now I guess I'll turn it over to Garrett. He'll talk more about the private sector, how they pursue collections, and how you can settle with them, and what your options are. Garrett, please.
Hi, everyone. So my name is Garrett Charity. My law firm is McCarthy Law. I've been there a little over 8 years now. I practice debt settlement law. In essence, what that is negotiating and litigating debt outside of bankruptcy. And basically, all my clients are coming to me with private student loan debt that is behind in monthly payments. And once it is behind in monthly payments, I can start reaching out to those creditors and trying to make settlements on those student loan payments. In general, people want to ask me exactly how much am I going to pay back? With the creditors that I take at my firm, let's say you owe $100,000, including my fees to get the job done, we're looking at trying to settle around 60% of what that is, or $60,000. And we do this so many different ways. So outside of litigation, I'm looking at building a hardship profile for my clients and sharing that hardship with the creditors, in essence, to try to get that number down, work it down as low as I can. And for many of my clients, stretch it out over as many monthly term payments as possible. As far as litigation and legal remedies to get this done, the Truth in Lending Act has been very helpful in my practice. I'll comb those documents pretty meticulously to make sure that they made the proper disclosures in the proper way. And if they didn't, I can ding them for Truth in Lending Act disclosures. This is all for private student debt. I can ding them for for Truth in Lending Act disclosures, and that helps me also get the debt down and possibly sometimes get damages for my clients. Also, too, when these debts go so late, and people may have seen this out there too, lots of these private student loans are bought and sold. And with that buying and selling of them, you often have problems in the chain of title with those debts, which creates a standing issue to even bring these lawsuits on my clients in the first place. So I'm in my trial briefs, in my discovery, I'm always attacking standing and looking at the chain of title documents, but I'm also looking at if they have a power of attorney and what those power of attorneys look like for the collectors who are going after my clients to see if those power of attorneys are in order. And oftentimes I do find that the chain of title documents are in disarray or those power of attorneys are in disarray. And that allows me to attack that they don't even have the standing to come after my client and collect these debts. What I'll say is many times it's not so much the issue of getting the numbers down to an acceptable level where my clients can figure out a way to take a settlement. It's paying for that settlement that's the issue and coming up with that money. In the early years of the practice at the law firm, we always were getting these debts down, but the student loan debts were so high that we couldn't figure out a way for the clients to pay for them. Now we had some clients that had property, had equity in their property, so they could take out a second or a HELOC and come up with the money at a low interest rate to pay down that lump payment. There are some lenders where I'm able to extend out those monthly payments quite far, where they're able to take the monthly payments. More recently, we were able to find a few lenders that will work with my clients and their co-signers that will actually lend them the settlement funds to pay down that student loan debt, and they'll crunch the numbers for themselves. So let's say I do a settlement for a client that's $40,000 on what was $100,000 of student loan debt. And we'll go out there and shop around to a few lenders and see if we can find that $40,000 loan that makes sense for them, that brings down their monthly payments on that loan lower than it was on the $100,000. And I can oftentimes bridge the gap and settle those lawsuits by some creative lending. I'm glad the tax attorney is here because all of this student loan debt forgiveness that I do needs a referral source for a tax attorney very often to talk about how the debt is going to be handled when you got issued a 1099-C or that 1099 forgiveness. And there's many different methods to get rid of that, and I'm sure that probably will come up. For many people, and for some of my clients, the Consumer Finance Protection Bureau has been a good source for complaints if they are not in litigation and we want to attack the standing, or we want to look for the original loan documents to look for Truth in Lending Act violations. I've had success there in getting documents outside of litigation. Also, there are some other issues to consider here when you're going into debt collection issues. And mainly those are the Fair Debt Collection Practices Act. That's the federal debt collectors law. The local law here in California, the California Rosenthal Act. And then also, I'm also looking at Fair Credit Reporting Act claims. The reason being, in the Fair Debt Collection Practices Act, the FDCPA, there are some great clauses in there for us that prohibit the collection of debts using misinformation. And a lot of times that misinformation could be the balance of the debt. And I find a lot of issue with the debt being the wrong balance, and I can attack the collectors on FDCPA claims, Rosenthal Act claims, and if that debt is reported on their credit report, Fair Credit Reporting Act claims, which all helps me get that debt down to settle it for less, but many times also puts money in the pockets of my clients. So I have a very niche practice with private student loan debt. It's not for everybody, but it's a great option out there for people who are in a jam, behind on their private student loan debt, but don't have the option of bankruptcy, obviously, for these private and federal student loans. And we can oftentimes work out some sort of plan that is usually unique to every client, where I can make a settlement on those private student loans. And that's pretty much it for me.
Okay, Garrett, I just had a quick question. Do banks, I guess, do these lenders, I mean, they seem to be, or at least they're perceived to be pretty strong about not selling because, it's not dischargeable in bankruptcy, so there's nothing you can do. Has that been the case, or are they flexible about settling?
Depends on the lender. There are some that I won't take at the law firm because I know they either settle too high or they won't settle. I can tell you that many of those, so we operate in all 50 states, and many states have some state loans that won't settle. So I don't think those, even if they came from private money. But the ones that do settle, and there's a long list of them, you know, bound by confidentiality, so I probably shouldn't, you know, spout off who's settling and who's not. But I won't take anything I can't do. And generally, they all will, anything I take will settle. There's maybe 10% that won't.
Okay, like what factors have you seen that increase the chance of selling for less than they owe? I mean, like age or disability, things like that.
Age, disability, great hardship, hardship. So I have a lot of client stories in this department. One of my clients was a dentist, and she very sadly had a miscarriage, and she had to go through some mental rehabilitation and physical rehabilitation from her miscarriage, and she fell behind on her private student loan, and we were able to settle those much lower. My highest client, my highest debt for a client, she had $534,000 of student loans, and she was in the entertainment industry, and they were in default for a number of years, and she was facing lawsuits from Navient and a few others, and basically they wanted the money is why they were willing to settle. They'd been uncollected for so long. She was facing many lawsuits, and then lo and behold, she got an amazing job writing for a mainstream major network TV show. It was all of a sudden making $15,000 a month, and we were able to have some funds to clean up such a large student loan debt. So, but as I said, I will attack those documents for Truth in Lending Act claims and the standing claims. I hate to say it, but and I'm sure many people have experienced too, but the lenders are really messy and the banks are quite messy. And I usually can find some disclosure that wasn't made properly, either a final balloon payment or an interest rate that wasn't disclosed properly in the paperwork. And those help me get those debts down.
Okay. I guess just one question for me. It's just like, okay, I mean, there's a good number of people here. They probably make decent money, but they probably want to see if there's a way they can settle their private loans. Are creditors willing to private loan service? Are they willing to do a settlement just like based on your income? I mean, you can just kind of. Are they willing to maybe negotiate like on a before it gets to litigation, or do they have to wait until they get sued?
Good question. Generally not. Generally, you have to be missing payments before we go into this conversation about settling it for less. And that conversation is very often the wild, wild west. It's been so many different creative options to settle these debts. I usually go in very low. I offered something like 10% in the very beginning to get it done. And we just go back and forth until we find something that works for both parties. What I can say though is for those people who are not in default, I have seen people have success with getting the interest rate lowered through Consumer Finance Protection Bureau complaints, interestingly. And I have seen some success with those with really great hardship. And these are very significant hardships. Maybe they lost a spouse in a catastrophic accident or had cancer. Trying to think of past clients. Many of my clients had their whole industries go under for whatever reason, or were part of a documented scam or a documented fraud in their industry that I could share. And for some of those clients that were current, I did see a few of their interest rates knocked completely to zero. So it wasn't that the debt was forgiven for less, but they were paying down an interest-free loan all of a sudden through a new agreement based on hardship. Something else I forgot to mention, which I was going to say earlier, is for these private student loans, be aware of clauses that accelerate the loan if anything happens to your cosigner. I have seen some not great cases where a cosigner goes bankrupt, or something changes or a cosigner passes away. And all of a sudden, the private student loan lender accelerates that loan because you lost your cosigner. Really nasty stuff that I've had to, so.
Okay. All right, well, thank you very much. That was very informative. I definitely learned a lot. Let's see. Okay, so now let's just go back to the federal side. Okay, so there's a couple of things you can do. I guess I mean the general the standard payment you can pay your loans off within like 10, 30. If you do the extended payment plan, you can set up a 30-year payment plan. But there are a number of income-based repayment plans. The most and then these are the three most popular. The traditional income payment plan is basically your monthly payments, and your monthly payment is based on 15% of your discretionary income, and I'll get to what that is later. And then after 25 years of repayments, the remainder is forgiven. As the law stands right now, whatever amount is forgiven is taxable income, so you have to include that in taxes. The problem is some people are owing six figures right now, and I mean some people may owe on probably like maybe $300,000-$400,000. I mean, if you convert that into taxable income, I mean that can be a pretty serious tax bill. One way to get out of it is by one planning aspect you can do is minimizing your assets, so we can minimize the taxable income by claiming that you're insolvent. So generally, what I'm doing with some people right now, they're kind of on the second half of their pay as you earn or income based repayment. So that we're making plans to minimize your assets. So assuming the worst, that the loans are forgiven and it becomes taxable income, we can maximize their insolvency and minimize the cancellation of debt income, so that by minimizing their assets. I think, however, as time goes by, probably in about 10 years, I'm pretty certain that I think there's a very good chance that Congress will change the rules so that the cancellation of debt from forgiveness of student loans is not taxable. I'll give you another example. Back in 2008, when the mortgage crisis happened, a lot of people were underwater in their homes. So when they walked away, uh, their bank pretty much gave them a 1099-C because they walked away from their mortgage, and then they also faced a huge tax bill because of that. And Congress as a response, they passed a law. I don't know the exact wording of the law, but basically it says that if you lose your home at foreclosure and you get a cancellation of debt as a result, 1099-C, then it will not count as taxable income. So I think if the problem is big enough, I think there will be a change in the law to address it. So I wouldn't worry too much about it. But I think in the next couple of years, as some people are in the tail end of their income-based repayment plans, we'll probably be focusing more on that issue. Okay, so the next one is the pay-as-you-earn. This one's a little more generous payment plan that was passed in 2009. The monthly payment is based on 10% of your discretionary income, and you get forgiveness after 20 years of payments. Okay, the next one is another recently revised one. It's called Revised Pay As You Earn. That one, I think it came into existence around 2013. Basically, it's again similar to the Pay As You Earn. It's 10% of your discretionary income, and forgiveness after 20 years for undergrad. But But if you have graduate degrees, aka law degrees for us, the payment will be 25 years. There's also some interest stops accumulating at some point, but that's outside the scope. Okay, but anyway, the trap here is if you're going to, I would at least for unmarried people, I would advise against going into the revised pay as you earn. The problem with that is no matter what, if you're married, then both you and your spouse's income will be taken into consideration when determining discretionary income. If you're on traditional IBR or pay as you earn, then you can file separately so that your spouse's income will not be considered. However, there's a drawback to that. In most cases, if you file separately, then you might actually have to pay a higher tax. So you have to kind of take that into consideration. I work with a lot of people. I prepare tax returns for people on income-based repayment plans, and usually they're married. And usually one thing I do is we do a comparison to see what their student loans will be and what their tax bills will be if they file jointly versus separately. And then we make a decision. We do the comparison, and then they make a decision based on that. So you definitely want to make sure you know what you're getting yourself into when you get to one of these plans. Okay. So what is the definition of discretionary income? It's basically well, there's two ways of calculating, but basically it's your annual income subtracted by 150% of the federal poverty guidelines. You can usually find this on the internet. It's usually based on family size. But if you're just a person by yourself, then it's only one, I think the 150% of poverty guidelines around like 18,000. So whatever your income is, your annual income is subtracted from 18,000, and then divide that by 12, and then multiply that by 0.15. I'll kind of show you in the bottom, and that's kind of how you get it. Usually for most people, it's a pretty manageable payment. Unless you lost your job or something happened, and in light of COVID, that's been happening fairly recently. Okay, so as I said, the discretionary income is determined by usually your adjusted gross income on your tax returns. If you are filing jointly, then you and your spouse's income will be calculated together to determine your monthly payment amount. The other is your income based on your paychecks. So if let's just say you lost your job, or if your income took a big hit, then you want to call your lender and say, look, this is kind of what happened. My income went down, I got laid off, or something else happened. For solo practitioners or people who have their own firms, what you can do with lenders is just provide like a profit and loss statement. Just basically list your income and your business expenses, and then your net income after that. After your net profit will be used to determine your monthly payments. So it's not really just relying on your tax returns. So let's just say your discretionary income is 72,000. Then your monthly discretionary income is 6,000. And then if you're on pay as you earn, which is 10% of your discretionary income, then your monthly payment will be 600. Or if you're on a traditional income-based repayment, your payment will be 900. So, I mean, if you're getting 6,000 monthly, it isn't too bad. I mean, it's still quite a bit of money for some people, but it's not that bad. Okay. The other option for forgiveness is the public service loan forgiveness. Basically what you have to do here is you have to work for a 501c3 approved tax exempt organization. Usually this involves most legal aid or government agencies. Those are usually the most common. You have to be working there at least 30 hours a week, and your monthly payment will be based on your discretionary income. And after 10 years after working there for 10 years, you'll be eligible for forgiveness. There was some recent news that that of the many people that applied for forgiveness, because the first round of forgiveness applications were sent in 2017, and only 1% of the applications got approved. Of course, that was a shocking number, but turned out some of the reasons why was because like some of the loans were not eligible for PSLF, and others they just didn't have the right paperwork. So hopefully this 1% will increase. But make sure that you have to certify that you worked every year and submit it to your lender so that it counts towards your 10-year period. The good thing is if your loans have been suspended because of the executive order or the CARES Act, then it's still counted toward your little furlough period is still counted on the 10-year period, so you don't have to worry about that. I guess the one good thing is it kind of gives you a disincentive to not pay because you're pretty much throwing your money away. One thing some solo practitioners might want to do is they might want to just set up a nonprofit law firm. I've seen some people do this in rural areas, usually because the population's there, they don't make a lot of money, so they can only afford to pay so much. So what some solo practitioners did was they just pretty much set up their own mini legal aid. And I've heard that they use some sort of sliding scale for payment. And by doing that, you're pretty much create your own 501c3, and then also eligible for PSLF. If you're interested in doing that, feel free to give me contact me later, or if you know a nonprofit attorney, you might want to contact that person as well. Okay. Now the next one is about it's not a really popular, it's not a well-known method. It's called the borrower defense to repayment. Basically what this is, the federal government will forgive federal student loans if you have proof that the school engaged in conduct that would violate state law, and you relied on it. Um, there's a lot of regulations on this, and it kind of depends on when you took out the loans, but they're kind of similar. But um, right now, I think in light of a couple of years ago, like some of the for-profit schools like Corinthian, they all went bankrupt and they closed. And I think a couple for-profit law schools run by Infolaw, and there was one run by Infolaw, I think one was like Charleston. A couple of schools, they were being investigated and they were shut down. So as a result, they applied for discharge in one of two ways. One was the closed school discharge, and the other one was this one, borrower defense to repayment. Okay, now I kind of bring this up now because, okay, the government generally looks at misrepresentations about selectivity, um, whether the school is selective as they say they are, whether the rankings about the school is accurate, whether the credits you earn at the school are transferable if you want to transfer somewhere else. And I think the most important is whether the claims regarding postgraduate employment and salary are accurate. I graduated in law school in 2005, and a few years afterwards, there was some news about certain law schools fudging their numbers about employment. If you looked at the U.S. News and World Report, you probably seen that certain schools, you were surprised. I mean, they're reporting 160,000 a year because they're working at a major law firm, but it turns out that wasn't the case, because only the people who made the large salaries reported, whereas somebody who was working some dead-end job or not working, they did not report. So they just kind of used those statistics to say, oh yeah, the students who reported were making high salaries, and they were kind of using that to inflate their numbers. Anyway, the New York Times, they published a story about that back in 2010. It created a lot of noise. And a couple of years later, a law firm, they sued, I think like 13 different law schools. There was a class action lawsuit. And then unfortunately, most of them dismissed. But one, I think it was Thomas Jefferson. That one actually made it through discovery and a jury trial. The problem was the jury found for the schools because the reasoning was that the plaintiff should have known better. You're a lawyer. You should be skeptical about schools' marketing claims. Okay, so but anyway, I think this is still available. The problem is the last couple of years under Betsy DeVos, she was pretty against this. I mean, she wasn't really too fond of this program. She set up proposed regulations that would make it very difficult to, number one, even to apply. And second, it would be difficult to even actually get I had a couple of people who actually applied for borrower defense because I mean they went to a law school where they promised like the average graduate made like $90,000 a year, but it turned out like 65% of them were unemployed. The problem was this person, all she got was just her loan was just put on forbearance for like 3 years, and finally she got a no answer. Now, as you know, there's a new administration and there is a new, potentially a new Secretary of Education, and I'm hoping this person will be a little bit more forgiving. In addition, there is a lawsuit against the federal government. They want them to apply the older regulations, which allow you to apply within 6 years after graduation, as opposed to the current 3 years. So I guess the main point is just you might want to keep this option open in case new regulations come out, and you might have a claim, a borrower defense claim. Honestly, I think this is probably better for people who graduated before 2015. I think most people who went to law school recently, they kind of knew what they're getting into, so it's going to be hard to make a claim that the law school scammed me. So I mean, we'll see. Okay. Okay. I see a couple of questions. I'd like to save. I mean, I think the remainder is going to be fairly quick, so I'd like to save questions for later. But I mean, feel free if Dan, if you have a question that's interesting, let me know. Then we can address it. Okay. All right. And then finally, discharging student loans in bankruptcy. I'm not a bankruptcy lawyer. I'm a tax lawyer, but I have researched this issue for some time, so I know a little bit about this. Okay, so generally student loans, government and private, they cannot be discharged without showing undue hardship. Now, undue hardship, that doesn't sound too hard. The problem is they're using most federal courts are using a test called the Brunner test. Um, the Brunner test, in order to show undue hardship, you have to meet the Brunner test, which there's three factors. One is based on your current income and expenses. You cannot maintain a minimal standard of living for yourself and your dependents if you're forced to repay your loans. Also, your current financial situation is likely to continue for a big part of the repayment period. And three, you made a good faith effort to repay your student loans. Okay, this doesn't sound too bad, right? It doesn't sound, the language doesn't sound too scary. The problem is the government, or at least most of the federal judges, they look at this very harshly, or at least that's kind of how it's perceived to be. And there are court cases where I've seen a court case where like some old lady, older senior citizen, like 80 years old, she's living on Social Security and only gets like $500 a month from her pension. And she applied for bankruptcy. Then the court still didn't grant it because the court said that, well, you could have used that 500 to pay the student loans, or you went on vacation 5 years ago to the Cancun or something. So they kind of use all these little, they kind of nitpicking. And I think it kind of encouraged the lenders to really dig through a petitioner's financial history to find little nitpicking details. And unfortunately, the courts really do look into that. And it's actually kind of a notorious reputation for that. Personally, I think the reason why they put the Brunner test, you have to keep in mind that Brunner was decided back in 1985, and the rules were different then. They had a period where a student loan couldn't be discharged for the first 5 to 7 years, no matter what, unless you showed undue hardship. Now, the case of Enright Brunner, I'm not going to go into detail, but the case here, the petitioner, she filed for bankruptcy like 8 months after she graduated. 8 months. I can totally understand a federal judge being pretty strict about this. Otherwise, a lot of us probably would have done the same thing. But unfortunately, I think the problem was, I think their reasoning just kind of is no longer appropriate for this day and age, with like a lot of people having $200,000 loans. That's pretty much a common number now. Okay, if that wasn't bad enough, there's one more hurdle to go through. In bankruptcy court, you can't just go to a typical Chapter 7 or Chapter 13 hearing. You have to go through what they call an adversarial hearing. And basically, it's just like a mini civil lawsuit. You file a petition, the lender will file their answer, and they'll kind of go through a discovery process where certain lenders will really go through your financial history. You could be subject to a deposition, and it's just like I said, it's almost like a civil procedure. Anyway, if you want to know more about this, you can talk to a bankruptcy attorney. I'm sure they'll probably tell you more about it, but I think the biggest problem is it's just a cost, and it turned off a lot of people. Okay. However, I do want to point out two interesting cases that came up just last year that might change how things are being done. The first one is a matter of McDaniel. It was decided about 6 months or mid 2000s. There, the 10th Circuit, I think this case was in Colorado, they held that that private student loans are not subject to the undue hardship standard, which was kind of interesting. Their reasoning was that private student loans are not what they call funds received as an educational benefit. You have to understand that the undue hardship rule applies to what they call loans made by the government agency, qualified education loans as defined by the IRS, or as opposed to here where it says funds received as an educational benefit. So what happened here was, it's kind of interesting because the lender was trying to argue that this is non-discharge, private funds are non-dischargeable because they're funds received as an educational benefit. But the court said, well, this is not the private loans are not an educational benefit because the language said it's either an educational benefit or a loan. So educational benefit has a totally different meaning. So it does not apply to private loans. Now, if this sounds kind of strange, I would agree with you. I do not know if some of the other circuits will follow this because it took a lot of what they I guess semantic gymnastics. There's a lot of they used a lot of rules using the English language, and reading the decision was just really it was really time consuming. Okay, the next one, which was kind of interesting, was the matter of Rosenberg, which was decided in the New York Bankruptcy Court last year. And I actually talked to this guy. This one, he actually did the whole thing by himself, the adversarial process, all by himself. He didn't have a lawyer. I mean, he did go to law school, but I mean, he wasn't licensed to practice. So he was running like running a travel business, and he was owing like several $100,000. He said he couldn't find a job in the legal industry, so he had to start his own gig, and his travel agency wasn't making that much money, and he was pretty much underwater. So he filed the bankruptcy for himself, and he did the adversarial proceedings by himself, and he actually did. It wasn't as hard as he thought it. According to him, it wasn't as hard as he thought it'd be. And ultimately, the bankruptcy court, they ruled in his favor. The judge said that he met all of the undue hardship standards. But I think the court's I think the money language here. The court said this court would not perpetuate the myth that student loans are impossible to discharge in bankruptcy. I mean, I think that's a strong statement right there. And this coming from New York, where they decided Brunner. The problem is his lender did appeal, and right now I think it's in district court right now. Good news is a lot of people, they filed amicus briefs in his favor, including Cravath, Swain Moore, a couple of other consumer advocate groups. Right now, the court is still considering it. So hopefully we'll get a decision in the next couple of months. Okay, but I think generally for people who want to look through student loans in bankruptcy, I think you should probably at least look at the cases on certain cases where they have been discharged. From what I've seen so far, it's not as difficult it's not as hard as people say it is. I mean, a lot of people on the news saying, "Oh, it's impossible to discharge," or you see all these horror stories. But I mean, some people do get their loans discharged. I mean, I wouldn't recommend filing a bankruptcy like a year after graduation. Otherwise, you're going to get laughed at. But I mean, if you try to pay for maybe 10 years, you've done your best, you didn't buy like a Porsche or a Tesla, you didn't live lavishly, then you might have a good chance of getting some of it discharged. So you might want to definitely look into at least some of the case law, and hopefully you might find something that fits your fact pattern. Okay. All right, so just a couple of loan forgiveness strategies. Okay, first of all, I think for younger attorneys, if you're sort of considering looking for a job, then you might want to consider getting a job in the government or the public sector, public interest sector, to get yourself put on public service loan forgiveness, so that you can get your loans forgiven in 10 years as opposed to 20. Alternatively, consider setting up a nonprofit for your solo practice, and in that way you can qualify for PSLF as well. I mean, I wouldn't recommend just filing a 1023 and applying for tax exempt status immediately. I would definitely recommend consulting with a lawyer, or at least consulting with the local legal aid, and just kind of talk to them and see what options are available, or if you can actually work with them, and then maybe you can get PSLF treatment without actually setting up your own nonprofit. Third, get out of if you're in a situation where you're in default, or if you're in collection status, get out of it as quickly as possible. It's not. I mean, living under wage garnishment, it's not the most pleasant in the world. And then no matter what, get on an income-based repayment plan as soon as possible, even if you think you're going to pay the same amount as you would under a regular payment plan. It's really so much as to starting the forgiveness clock, because you never know. I mean, in the legal career, you never know when you're going to get laid off. You never know when your practice area is going to take a slump. So you kind of want to have that clock ticking just in case something happens. And then ultimately, just when you do choose the income-based repayment plan, pick the one that's right for you. I think in most cases, it'll just depend on whether you're married or not. If you are married, you might want to just stick with the traditional pay as you earn plan, because you won't have to consider your spouse's income when making payments.
Hmm.
Okay, now just a couple of minutes, maybe you can participate, but now there's some talk about loan forgiveness. Okay, so President Biden's, during his campaign, he supported forgiving $10,000 of existing student loans. He didn't clarify as to whether this is private loans or just federal loans. My guess is it's only federal loans. I'm not sure if he has any ability to cancel a private debt. However, Democrats, I think Chuck Schumer and Alicia, or I'm sorry, AOC, I forgot her full name. They're proposing for $50,000 minimum, and Bernie Sanders, when he ran for president, he was just advocating for full forgiveness. So, hold on. Sorry about that. Okay, 1 second. Okay, sorry about that. Okay, but anyway. Yeah, so I think the problem here is I think there's going to be a lot of people that want to, obviously this is really based on self-interest. Some people want to get loans forgiven because they owe a lot. On the other hand, there's some people who pay down their loans, and they're gonna argue that, you can't. Why should I paid off my loans, you should be able to do it too. So, it's a personal responsibility crowd. And then also, not only that, lately it's just become less of a financial issue, but it's also become a political, socioeconomic, and racial issue. I'm not going to get into details, but just people are arguing. Some people should get forgiveness based on wealth. Other people say it should be total regardless of who it is or how much money you make as an economic stimulus. So ultimately, personally, I think just there needs to be a permanent reform in education and student loans before even we discuss forgiveness, because we can forgive, everyone can someone can write a pen and forgive everyone's debts tomorrow, but the next year's graduates, they're going to owe student loans as well. So maybe that's what it should be, a free educational system. But until then, I think probably the best thing to do is to try to fix the system so people won't be leaving with like $90,000 or $200,000 in debt. And ultimately, I think it's probably not going to happen until the next generation of politicians, because like right now, most politicians are in their 60s and 70s. They're a little bit out of touch as to, some of them might have children, but most of them, they paid off their student loans. But during their time, college was like $500, and law school, you can pay for law school by selling your used car. I think that's what one past ABA president did. Okay, so I think ultimately, yeah, loans. I think I wouldn't bet on putting a hold on loan forgiveness at this point. If you're still making payments, you should probably do it. If you're making I'll just be honest here. If you're making a decent amount of money, I know it's gonna be hard to write a 6-figure check when you could be purchasing a house or Bitcoin or a Tesla or whatever. But from my experience, from people who paid off their loan, they tell me it's the best decision they ever made. So because they don't have to worry about all the collection nonsense that we dealt with earlier. Okay, well, that did it for me. Anyway, thank you for listening to my rant here. If you have any questions, I can kind of go over it. Let me see.
Q&A, by the way. You want me to read these off for you?
Yeah, we can do that, and then Garrett can chip in if he wants to chip in. Which
the first one, Garrett's actually answered this in text, but Garrett, will just throw it your way in case you want to add anything. And it's hi, and let's go ahead. Actually, if we could turn off the screen share at this point, Stephen, I think you got that. And then, in fact, here, why don't we do?
Oh, here we go.
There we are. And we got perfect. Okay. So, Gary, you had already answered this, but let's go ahead and throw it out there. And Stephen, please chime in. Hi, what should one look for to see if the balance is wrong in student loan debt? How can you figure that out without being an accountant?
Okay, well, generally in those situations, number one, you're gonna have to do a loan amortization calculation by yourself, and then compare it with what the bank says. Usually, most lenders have their own dispute resolution procedures where they'll give you a transcript. I think the problem in these type of situations is when you're in collections and then a collection agency puts in like some collection fee, which is like a percentage of the debt you owe, and then they put interest on top of that. So that's why you might not know exactly what you owe. But I think generally what you want to do there is number one, check to see if the penalties they assessed were accurate, and then also do your own amortization table based on what your interest rate should be. And then you have to look at your loan contract. But yeah, there's kind of a problem where some people do not, unfortunately, they kind of don't pay attention to their student loans. This kind of happens sometimes, or if it just goes into collections and then the collection agencies, they hit you with penalties, all kinds of penalties, and it just exponentially raises your debt. So yeah, I mean, I think you'll have to go like one of those amortization tables and then calculate what the interest accrued should be, and then present it to your lender and see what they do with it.
I would just add, check your credit reports. Annualcreditreport.com gives you 3 free credit reports, not the score, but just the information. And the reason I say that is because debt collection is messy and they make a lot of mistakes in credit reporting. And you could give it to someone like me or someone else to review, and I can comb through that credit report and see if I can find errors there. And errors sometimes help you get down that student loan debt, and also can avail you to other plaintiff side actions.
What was that website one more time, Garrett, just for everyone?
Sure, annualcreditreport.com, and I'll add it to the chat too.
That's wonderful.
Yeah.
I love that it's free.
Yeah, and I mean the trick is you go to like one every 4 months, so you can kind of get it three times a year.
Okay, we have another one. Does a petition for an ability to pay determination apply in this context and in credit card debt context? I've seen it used in traffic school.
Okay. Well, generally, on the federal side, you kind of have to just, depending on the lender, but most of the people I work with, they're pretty good about it. You just show your last couple of pay stubs. You show your rental payments or your mortgage payments, and then maybe just a list of your expenses. If you're a solo practitioner or if you run your own business, then just provide a profit and loss statement. If you can show like a decrease in income, then that should be enough. There's no need for any kind of like formal paperwork, at least as far as they're concerned. Garrett, has that been the case with the private sector?
No, we've, in court, we use those debtors exams to assess the ability to pay. And I haven't had that in my civil litigation practice.
Okay. Next question. What if you are on a board of directors of a 501c3 but are not paid? Is it still work?
I would check with your lender on that. Some are okay with it as long as you meet the 30 hours. But I mean, I would at a minimum just get paid, asked to be paid a small stipend and get like a 1099, or well, actually not 1099, but a W-2. And at least that way you'll have some minimal level of income just to at least for IBR purposes. But yeah, you have to check with your lender to see if they'll accept that. They kind of vary. I mean, well, not so much your lender, but your servicer like Navient or whoever's servicing your loans.
And Garrett, any thoughts on that?
No, just not my practice area, so I wouldn't have anything to add.
Understood. Next one, guys. So would you say the bar exam loan should be dischargeable in a BK because it's not a quote educational loan? Always assumed it's an educational loan. Really good to know.
Yeah, that's the thing about bar exam. I thought the same thing, but the thing is, with bar exam loan, they treat it like a personal loan because it's not distributed in connection with attending a school. I mean, like, I don't know. I guess Barbary is not an accredited organization. It's just a private. It's a private, just a test review center. So it's not you're not really getting an education. You're just prepping for the exam. So it wouldn't really qualify for undue hardship protection. Okay.
Garrett, any thoughts?
I I'm not a bankruptcy attorney. There are many bankruptcy attorneys here in the room. Elise is one of my good friends, and we've had this conversation before about getting private student debt discharged and student loan debt discharged in a bankruptcy. And they could assess the situation better from their point of view if it makes sense to do that adversarial procedure, depending on the judges out there. I think, as you saw in the New York case, some judges are kind of fed up with the myth that student loans are not eligible for discharge in bankruptcies. And I think some judges are letting these pass through now. So obviously it's, not a decision to take lightly because, there are legal fees involved. But if you have a, significant amount of student loan debt, I think it's worth having that discussion for sure.
Okay. Next question, guys. I am doing the public forgiveness for my loan. My husband and I file our taxes separately. Is this payment considered taxable income? Should we file our taxes together? Is there a benefit? And do we need anything on our taxes for my loans? I think that was about 4 questions. We can repeat those if need be.
Okay, so first question was your husband and is this payment considered taxable income? I'm not sure what you mean by payment here. I mean, the payment from the government or from the place you work for, yes, that's considered taxable income and it'll show on your W-2. Second question is, should you file your taxes together? Is it beneficial? Generally, I mean, I think you'll have to talk to someone and do like a comparison as to what your student loan payments will be, filing jointly versus separately. Generally, I advise against filing together because the joint income will be used to determine your student loan payments. So, on certain situations, it might be better to file jointly because you actually end up paying less tax. I mean, you'll pay more in student loan payments, but less in taxes, and the net gain might be better that way. So you kind of have to do a detailed analysis there. And do we need to do anything on our taxes for my loans? That's a pretty open question. I'll probably need to know more about your situation. I mean, I think ultimately you should just definitely keep. I think the goal here is just to minimize your taxable income. Some people put money into an IRA to minimize their taxable income that way, or at least their adjustable gross income. So I think one thing you might, the only thing is don't look at your itemized expenses because that's not going to decrease your income. So you have, like charitable contributions, actually, except for this year, you could donate $300. So yeah, it's like medical expenses, state taxes paid. So those are not going to be considered when determining your student loan payment discretionary income. So do anything on your taxes? Yeah, it's kind of hard to say. I think you'll have to talk to your accountant and ask them to do like a cost benefit analysis of filing jointly versus separately. Okay.
Garrett, anything to add there?
Yeah, because I'm not a tax attorney, so.
I'm just going to ask you after all of them, I have a feeling. Okay. Next one. Are FFEL loans part of the federal loans being considered for forgiveness?
Okay, that one is an open question because federal loans are kind of like a hybrid. I mean, they qualify for income-based repayment. They're kind of like a private loan, but they're guaranteed by the federal government. And then back in 2010, the government just kind of got rid of the middleman and they just handled the loans themselves. I think one hint though is when the loan payment forbearance was given due to COVID, the FFEL loan was not covered, unfortunately. So some people do have to pay that. So that might be a hint that FFEL loans might not be eligible for the $10,000 forgiveness, although I'm sure many will agree that that should be the case. So we don't know yet. So we'll have to wait until we hear something from President Biden or from some of the Democratic senators or a congressman about additional details. So hopefully it'll be included. Okay.
Okay. Can I throw a quick one in here? This is a much more lowbrow question than the ones that have been asked. And I've had some people bring this to my attention as well. When my older cousins went to law school, their student loans, they're still paying some of them today, but they're paying $300-400 a month and it's easy riding. whereas I have $1,000 plus of interest alone a month getting accumulated on my student loans. Is there a reason it became so much more radically expensive, or do I just have a one-off example in my head?
No, unfortunately, yours is very common. The problem is law school tuition went up a couple times faster than inflation, and people went because they thought it was a good return on their investments. And I mean, there's like the mean old man side of me that says, like, you shouldn't have borrowed more than you had to. But at the same time, it's just like, you can't, you know, you know, you need to spend time to study. You can't just live on rice and beans and live with your parents and deal with family problems. Because if you don't, you have to be in the top 10% of your class. So you need to invest in good lodging so you can study better. So I mean, I kind of get that, but I think the problem there is just like, I think a lot of people, they don't really see their student loans accumulating. The other problem is at the end of the year, most lenders, they send you a letter stating that, okay, this is the amount of interest that accrued on your loans. Please pay this, otherwise it gets capitalized, meaning it gets converted into principal, and you have to pay interest on that too. So it's kind of like compound interest in reverse. So I mean, you kind of got the situation where banks are making a ton of money off of you, and what seems unfair is that the banks are getting most of their interest up front, and so even if you paid off your loans fairly early, they got a big chunk of the interest payments from you, and that's the problem. I think in cases like that, I think the problem was like people didn't, and this happened to me too. I didn't really calculate my student loans until I got out of law school, and I'm like, what the bleep happened? So, I mean, I kind of did the numbers, and it kind of makes sense. I was like, okay, but I mean, if I saw these numbers coming, I probably would have paid down. Maybe I could have just paid down the interest or something of that sort. But and then not only that, you also have undergrad too. So I mean that adds up.
Hmm.
So yeah, but
So
like
I think there's a big overarching answer here, which is where did all this come from? And in the history of student loan debt, this came from Sally Mae becoming a private entity. Sally Mae was a Fannie or Freddie encouraging private loans to, that were government backed to be, loaned to the American population to encourage education. And then Sally Mae started making private loans itself directly. And then Sally Mae left the government and became a private entity and started making all these big private student loans, but they had their lobbying power from being a government agency and were able to make this crazy situation we're in where you can't bankrupt, or it's very hard to bankrupt student loan debt. So, and I see a question coming on Navient, it really is kind of a terrible story of where all this came from, because we had, basically people at Sally Mae with insider connections to our government. They were able to create this problem where you can loan young people $400,000 with no collateral and no opportunity, or a very difficult opportunity to bankrupt them. So, Navient is a company that basically is just Sally Mae under another name. They were getting such terrible press and such terrible feedback from their administration of their student loan debt, and they spun off and became Navient just to be a different entity and a different name. And they're basically just the same terrible people that had insider connections to create the problem that we're in today.
Oh, yeah. Interesting. Okay. Next question. Even if education loan, how do you know if it's federal or private? Does it have to be from Department of Education specifically?
okay, well, I
Always.
mean, yeah, I mean, the easiest answer is just give them a call. Give the lender a call. I mean, usually a debt giveaway, the direct loan pretty much says it in bold print, like federal direct loans. Navient, I think they do private and public, so it's kind of hard to say. There's certain places like AES that just handles public, and then there's certain that just handles privates. Usually, if it's like Chase or Wells Fargo, they probably just do it themselves. But I think the problem right now is it's just like a lot of the student loan lenders, they're pretty much they're pretty much selling their student loan assets elsewhere. So you might, like 6 months later, you might get a letter from a different company. Um, this is usually the case with, I guess, subprime loans. People who have been like delinquent or not paying on a regular basis. You're gonna see companies change here and there. So we'll see. But yeah, I mean, to answer your question, just yeah, the dead giveaways. If you see the words direct loans on the paper, that's probably it. But yeah, I'd probably just call your lender, or maybe look up the name on Google, see what they say.
Yeah, and all I would add to that is there are, I think, 4 major federal collectors. Correct me if I'm wrong. Fed Loan Servicing and Nelnet and a few, I think, Great Lakes. But there are a few you can Google and see exactly to see if they are federal, they're collecting federal or private student loans. And the other telltale sign is if they're offering you income-based repayment. If they're offering you one of these federal programs, 25 years, 30 years, you know, or the public service forgiveness, then it's a telltale sign that it's a federal loan.
Okay, wonderful. Okay, next question, guys. Garrett, this one's directed to you. Are you able to make loan settlements with Navient? And if so, what percentage do they settle for? I think you may have even touched upon this earlier.
Yeah, it's well documented online that Navient does settle their student loans in default. Generally, the bullseye for a good settlement is about 6 months, maybe after charge off, 6 months to a year. And generally, I'm, you know, in litigation and trying to do the best for my client. So I'm trying to get, you know, 30s, 40s, 30%, 40% on Navient student loans. But in general, with all debt settlement work, they're willing to take a bit less if you can come up with it fast in a lump sum, and more if you have to extend out those payments over a long period of time. So if you have a great cash flow and you can come up with a large lump sum of money, then you're probably going to get a lower settlement. If you don't have that cash flow and you have to spread this over a term of payments, then it's probably going to be a higher percentage settlement, but stretched over a time period that you can actually afford.
Interesting. Interesting. Steven, you have anything to add to that?
No. That was very good.
Here's an interesting question. Could you touch on COVID long haulers who are too sick to work? And this is, by the way, this is submitted anonymously. Madam or sir, if you are in fact a COVID long hauler, I hope you're doing all right. I wish you the best. Let's see if we can help you out here.
COVID long haulers were too sick to work. I think for the federal loans, I mean, you just let them know that you're out of work, and usually they'll just put you on some sort of forbearance, or they'll just adjust their monthly payments to zero. But you'll have to contact your lender. But at this point, right now, it's kind of hard to say because most federal student loans are suspended because of COVID. So maybe in October, when the collection period ends or the forbearance period ends, you might have to repay. But also, or at that point, you may want to call them and say, "Hey, look, I'm a COVID long hauler. Um, I'm having coughs, or my employer doesn't want me back." That kind of thing. But it's kind of hard to say what it is right now. I mean, I'll say it. I had COVID. Thankfully, it didn't last that long, but who knows? I mean, I might be sick 3 months down the road. So, I mean, yeah, just get like a doctor's note and just present it to your lender, and hopefully they'll provide something or give you some sort of relief.
In the private student loan sector, there's no great answer for this. And why I say it that way is because even today, I submitted a motion to quash a service of summons. The lenders have been very aggressive, and so many people have been displaced by COVID that they're being served lawsuits at addresses that they no longer reside at, or they've been couch surfing, or they've gone to live at home in quarantine, you know, with families. And lenders are serving suits on debt in default and going for default judgments literally days after the answer was due. So what I can say is, if you are COVID long hauler and you do have debts that are in default, do attend to them, get some help, check your mail. I would say attend to these. Now, have I been able to set aside judgments? Yes, for sure. We are able to get in there and show other lease agreements or all the different proof you would need to prove up a motion to set aside a judgment. But they are being aggressive. I thought I would certainly see more willingness to work with the my consumers. And the best I've seen is just extending these payments out over long periods of time while the interest is just accruing and accruing and accruing, outside of me settling it in litigation. So do pay attention to what's going on, unfortunately.
Okay. All right, guys, it's 7:45. Might want to wrap this up shortly. The catch is the Q&As keep coming. They like chatting with you guys. Obviously, I don't blame them. It's a lot of good information here. Why don't we try to do a lightning round and just get through these as quickly as possible, and we can wrap up. There's 6 pending, and hopefully it doesn't turn to 7 in a second. First one on the lightning round. What effect, if any, has COVID had on your ability to settle matters?
Okay, quick answer. Quick answer is it depends. Depends on the lender. Usually they're a little more sympathetic. Yeah, a little more sympathetic. You just kind of have to let them. You just kind of have to know that you lost your job due to COVID or you got sick, and then hopefully they'll work with you.
Same answer for me. If we're addressing it early enough, we are getting generally the same settlements we were getting before COVID.
Understood. Okay, next one. Hi, I'm signed up for IBR and pay the minimum amount to Navient, which barely covers the interest. Sounds familiar.
Yep.
What do you suggest if the best approach to attack the loan? I'm not even making a dent because the amount of my loan is significant and I am unable to pay enough to even touch the principal. Yeah, I think a lot of people are in that shoes. What do you guys think?
Quick answer is, I mean, it's really up to you. If you're making if you're making decent money, you might want to pay it down. If you don't have that option, you just do what you do what you can, and then maybe look into switching to PSLF or just reducing a lower payment. I mean, I think if you're in the early stages of IBR, then I'd focus more on your career, and then at some point you'll figure out whether you're just gonna look for forgiveness or just pay it off. But yeah, it just kind of depends. But I think just ultimately for now, just if you can't afford to pay, then just stick with your IBR plan.
Yeah, and that question comes to me a lot with my clients, a federal student debt, and I agree wholly. If you're in that situation, unless you have some windfall of cash at some point, then you're just going to be waiting for that forgiveness time period.
Okay. Next one. Garrett, to you. Have you ever worked with a loan that was consolidated by a company named Graduate Leverage? Now, one thing I might just want to throw out here, guys, we cannot give out legal advice with particular specificity on any. This should not be construed as legal advice. This is not an MCLE seminar, and we have this open to the public, which includes non-lawyers. So please bear in mind, guys, neither Mr. Charity or Mr. Chung is going to be able to give out specific legal advice. But anyways, putting that maybe overly cautious disclaimer out there, have you ever worked with a loan that was consolidated by a company named Graduate Leverage?
Sounds familiar, but I'd have to look at the paperwork and check it out. I'll put my contact information in the chat and I could look it up for you later if you wanted me to.
Yeah, not me.
I know we have some non-lawyers in the audience here, which was frankly the idea. Obviously, we would suggest reaching out to the panelists if you have a situation. I know Mr. Charity just put his information in there. I'm sure Mr. Chung will put him in there as well. And of course, you can always come into the Westside Bar Association Facebook group, and they'll be listed there as well. Okay, so let's move on to the next one. Do you think we will see an interest rate reduction for student loans, especially grad plus loans, anytime soon?
Hard to say. I mean, you're gonna have to. People are gonna have to pressure Congress people to do it. Yeah, I just don't see it happening unless there's a good reason to. You just have to bug your Congress people, ask them to reduce your interest rates.
Same answer for me.
All right, guys, 2 more. Let's power these out. With a settlement, are lenders willing to remove prior adverse credit reporting?
I love this question. Go for it.
You know what? Why don't you go first?
So this is just something ancillary to my practice. They often are very lazy with correcting the credit reporting, and I will submit our settled in full letter or our satisfaction of judgment or whatever I have as the proof that it's been paid and settled and should be reporting zero balance. And if not corrected, I'll file that Fair Credit Reporting Act lawsuit in addition to FDCPA claims for attempting to collect a debt that is with misinformation. And then also the California Rosenthal Act as well, which allows for dual recovery in California. So it's a great lawsuit. I file a bunch of them. And if they're not going to remove that prior adverse information, then we sue. And it's a great lawsuit because they often are very lazy with correcting that balance to zero balance in the period of time they're supposed to.
Okay, yeah, I mean here on the federal side, I haven't really seen them do it. Usually with them, you just get back into rehabilitation status. I mean, they're usually not like private entities where they kind of want their money now. I mean, the government, they kind of just want to get paid. They don't really have they don't have much of a time sensitive issue like private lenders do. But yeah, generally what I would do is, I mean, if you're going to settle a debt, I mean, I would definitely make it a part of removing the negative entity as part of the settlement. Otherwise, even if it means paying a little bit more. But yeah, that's pretty much the deal.
What I forgot to add in that Fair Credit Reporting Act lawsuit, I will ask for trade line deletion, and that will get rid of that past negative information.
Oh yeah, absolutely.
Okay, guys, last one. Haven't paid student loans in 20 years. 60,000 is now over 100,000. School lied and their program wasn't credited. So is there any legal help available, or is it too late? It's not on my credit.
Okay, yeah, you could probably try for the borrower defense repayment program, but I think as of the regulations now, it's too late for you to get any relief. But I'd probably submit it anyway. Maybe by the time your application gets reviewed, maybe there'll be new regulations on the books. Other than legal help, I'm not too sure on the private side. Garrett could probably be better.
Yeah, this just goes in, and I have seen this before with large student loans. If it was a private student loan and they didn't sue you in the applicable statute of limitations, this is just under contract law. State of California is 4 years. On installment contracts, it's the date of your last payment. So that clock starts running 4 years from the date of your last payment. And if you have not made that payment in 4 years and they fail to bring a lawsuit at that time, then sure, they could still collect it, but you can write them basically a go away letter, do not contact letter, and they stop bothering you. So if it's a private student loan that isn't reporting on your credit report, maybe they're just still hassling you, but you are past the statute of limitations, it's a do not contact letter is what you would write them to stop hassling you. But be careful about making any deals with them where you pay anything on that debt, because it could constitute a new contract. So, there's this category of debt, zombie debts, where they'll say, well, we'll forgive $20,000 if you make a payment on this or do that. And then all of a sudden you formed a new contract and you've restarted that statute of limitations. So, be careful about entering a new agreement if you don't know what your legal rights will.
Sounds like the audience should just reach out to you guys if they're in some deep trouble.
Yeah, I mean, my name is on the Facebook list, so just send me a direct message. Otherwise, if you're coming from above the law, then just email me or look for me on Twitter, and I'll definitely help. I'll definitely be happy to talk to you.
Okay. All right, guys. This was wildly informative. Really, one of my takeaways is there's a political pressure that needs to occur here. Those mentions here by the panelists that most people in Congress don't have student loans. Their age range is just out of that particular category. So it sounds like there is almost like a political activism message here, assuming, you want to get forgiveness, you got to make the politicians aware of it. I think, frankly, that makes perfect sense. Sounds like you got to start the IBR as soon as possible. Correct me if I'm wrong, guys. That was one of my major takeaways from this as well. And it also sounds like there's no magic pill, at least not yet. And we'll see how things go and where they go. If you guys have any further questions for the panelists, you can please reach out to them directly. I'm sure they would love that. We would love that. If you're in the WBA Facebook group, guys, please go in the group. Let us know if you like these things. Post tomorrow. Let us know tomorrow. Was this helpful to you? Are the smaller events like these ones, are they helpful to you rather than some, whatever the other ones that we do? Just give us feedback and let us know what it is we're putting together that is most beneficial to you, and we'll continue doing it. All right, guys, I'm going to quiet down at this point. Anything else? Any last closing statements?
No, thank you for coming, listening to my rants. So, well, best of luck with your student loans.
My best advice is always check your mail. Don't put your head in the sand. There's an answer, and it's a good answer. So if you're behind on student loans that are having trouble, contact somebody. They'll get you the right place.
Wonderful. And to our panelists, Mr. Chung, Mr. Charity, thank you for your time. Thanks, everyone.